thing. I guess it's working. Right. Good evening, everyone, and welcome to our event this evening on the power of branding, building and protecting your brand with IP Australia. My name is Lainey Bennett. I am the head of content and events for LegalVision, and I'm your MC this evening. And we are very fortunate to be joined by our two special guests. Um, on my left is Tracey Berger, who is the Hearings Officer for Trademark and Design Team in IP Australia, and our very own Rebecca Jones, who is the Trademarks Practice Group Leader for LegalVision. I'd like to start by asking you both to briefly talk a little bit about yourselves and to tell us, if you don't mind, what is the most common mistake that you encounter when it comes to brand protection? Tracey, would you like to go first?
Thanks, Lonnie. So, as Lonnie said, my name's Tracey Berger and I work for IP Australia. I worked in private practice with a large intellectual property firm for about 25 years before I moved across to the government. And now my job is to decide trademark disputes. So as you'll hear about later, it's possible to object to somebody else's trademark being registered, and when that happens, it ultimately ends up before me or one of my colleagues usually to decide. And if you don't like our decision, you can then appeal to either the federal court or the federal circuit court. Oh no, it's called something else now. Federal family court. We see lots of mistakes. It's hard to narrow down to one, but I would say, it's always best to file your trademark application sooner rather than later. Once you get involved in running the business, it's easy to forget, and somebody else might beat you to it with the same or similar mark and cause a big problem for you. The other thing I would say, because I'm going to have two here, is to think about who should be the trademark owner or who should file the application, because you can't always correct it if you get it wrong. And trademarks can be a really valuable asset of the business, so you want to make sure you have it in the right name. Sometimes it's good to talk to your accountant, and if the applicant for the trademark is not going to be the person who uses the trademark, then you probably need some legal help with doing a license and making sure you have proper controls in place.
Thank you, Tracey. Hello, my name is Rebecca Jones. I'm the practice group leader here at LegalVision. I have been working in the trademark space for probably coming up 20 years now, initially in New Zealand and now in Australia. I've been with LegalVision since 2020. As part of my day-to-day work, we assist businesses with the entire trademark life cycle, from brand clearance before adopting a new trademark, navigating obstacles that might come up during the examination or opposition process, as well as international trademark clearance and protection as well. I would say that one of the most common mistakes I would see is people being reactive rather than proactive when it comes to their trademark protection. Because it's not mandatory to register a trademark to be able to use it in Australia, I think people can sometimes get complacent and, it gets bumped down the list, something that will get taken care of later. But like Tracey said, it's always better, in my experience, to look at that sooner rather than later, and particularly be proactive about securing that before the issues arise, rather than scrambling to try and get that protection in place once there's already an issue on your hands.
Great. Thank you both very much. So this evening we are going to be talking about how a trademark, or what is a trademark, and how it will protect your brand from competitors, how to make sure your brand is unique and stands out, and making sure your trademark is actually available and enforceable, and the practical steps to protect your brand from and enforce your brand from opposition and competition. So we will share some tips. We will have Q&A after the presentation, so we'll answer your questions. And then afterwards, please stick around and have a drink and something to eat and network before we wrap up around 7:30, 8 o'clock. Now, just before we get started, a quick poll question. May I ask how many people here have actually registered a trademark? Excluding the lawyers from the business. Great, thank you. All right, so let's get going. Tracey, would you mind telling us a bit about what actually is a trademark and how will it protect your brand from competitors?
So a trademark is basically how consumers identify your business and your products or services. So often it's your business or company name or the name of your product, but it can also be a slogan, like Nike's Just Do It. It can be a logo, like their swoosh device. It can be a color, like the Tiffany aqua blue color. It could be a hologram, like NRMA has the ads where NRMA turns into the words HELP. It can even be a scent in very, very rare circumstances. So it's basically anything where when a consumer sees the product and they recognize something about it that makes them think, yes, that's such and such's business, or I bought that product before, and so this must be from the same people. Sorry, now we're on to the second part of the question. Oh yes, how does it protect your brand from competitors? So if you have a trademark registration, it provides you with Australia-wide protection, which is really important, especially if you're selling goods online, because you might be based in one town or city, but if you're selling throughout Australia or even internationally on the internet, you need to have protection more broadly. It's also protects you, gives you a monopoly. A trademark registration gives you a monopoly not just in the trademark itself, but also any similar mark, deceptively similar mark, and not just for the goods or services that you specify in your registration, but any similar goods or services. It's also a lot less expensive to enforce a trademark registration than an unregistered trademark.
Thank you, Tracey. You started to touch on it, but Beck, what are the risks of not actually registering your brand as with a trademark?
I would say the biggest risk would be the risk of inadvertently infringing a third-party trademark. So if you don't have your trademark registered and it's not there to function as a kind of shield to defend your use of the trademark, you may inadvertently infringe an existing registered mark in the name of a third party. So that's a risk there. And like Tracey touched on as well, although you can enforce in some ways an unregistered trademark by way of misleading and deceptive conduct or passing off provisions, enforcing a registered trademark is a lot more cost effective. You produce your trademark registration certificate as evidence of your ownership, as opposed to if you were trying to enforce an unregistered trademark, you have quite a high evidentiary burden in establishing that you have a reputation in that trademark. So obviously with a high evidentiary burden, the costs of that go up as well. Tracey touched on this as well in terms of the geographic scope. If you're attempting to to enforce an unregistered trademark, you'd also need to establish the location that you have that reputation in, whereas a trademark registration automatically extends to nationwide rights. So yeah, the geographic scope as well is a risk if you don't register it.
Thank you. So before, Tracey, you were talking about all the different ways that, that brand is represented, from colours to slogans and logos and so forth. How do you ensure your brand is unique enough to actually be registered as a trademark? And then once you've talked a bit about that, I'd like to touch on some of the pitfalls to avoid during the process. Thank you.
So this is more a list of what not to choose rather than what to choose. But in general, the most valuable and successful trademarks are those that are unique and don't make any reference to the business or the products and services it provides. So things like Apple, Google, Nike. So when you file a trademark application, it's examined by IP Australia and has to meet certain criteria. So it can't be descriptive. So things like fast car wash obviously is not a great one. I had a case earlier this year for the mark Oval for handbags, which was rejected because it's descriptive of a handbag that's oval in shape or has an oval pattern on it. Common names or surnames are also generally not acceptable because you might want to use your surname, but it could be many other people in Australia who also want to use their surname and operate their business under that name. Any term that's, and often with technical products, a term that's commonly used in the industry to describe something about the product or service. What have I forgotten? Oh, geographic names are also generally not recommended. So, you can't have Sydney Building Supplies because other people in Sydney who supply building products might want to use that too. So because the government gives you a monopoly in the term, you have to make sure that you're not going to stop someone else from conducting their business in a fair manner and using terms which should be available to everyone to use.
On that, you gave the example of Apple. It's really important to think about the trademark in the context of the goods and services that you want to apply it to, and that's what a trademark examiner will do when they're looking at your application as well. So for example, with Apple using that trademark in respect of electronic devices and things like that, obviously there's no descriptive connotation there. If you were to try and use Apple in respect of, fruit juice or fruit products, then you would have an issue with descriptiveness. So it really depends on the context of the goods and services that you want to apply it to as well to make it unique.
So Beck, we've got our brand. We know what we want to do. How do we know if it's actually available to register?
A really good question. So the first thing I would suggest is you want to jump on IP Australia's website. The trademarks register in Australia is publicly accessible and searchable, which is a lot better than some other countries. So we're quite lucky here that you're able to access that. So I would suggest jumping on there, searching to see what other trademarks are registered by other traders in your classes of interest. So when you register your trademark, you're looking at 45 different classes of goods and services. So you want to look at other traders that have registered potentially similar marks in the same or similar classes to what your goods or services fall into. So that's the first thing I'd suggest, is making sure there's no other registered trademarks that are going to form an obvious obstacle to your proposed new trademark, and also potentially present an infringement risk if you were to use that trademark without authorization. The other thing I would suggest doing is carrying out some searches of just on Google and different marketplace databases to see if there's anyone using the same or a similar trademark in your industry that might not be registered, but they may still be able to challenge your use or registration of the trademark based on their unregistered rights. And then again, the third thing would be making sure that it's distinctive, so not descriptive in relation to your goods and services.
Have anything to add about tools, Tracey?
Yeah, I'll just add one small thing. Try and think. Don't just check for your exact trademark. Try and think of like obvious misspellings or phonetic equivalents, because that's what IP Australia will be looking for too in order to raise an objection. So you. If you're applying for a particular spelling and that's all you check for, you might find that you've missed something that's orally identical or visually very similar. So try and think of variations to also double check for.
Thank you. Now, what about, we've got our brand. Oh,
Also mention, sorry, IP Australia's TM checker. So you can search the trademark register as Beck mentioned, but there's also quite a useful tool that IP Australia has that will have a QR code for at the end of the session, which is called TM Checker, where you can put in your trademark and it will look for some variations as well in your classes of goods and services. So that's also useful, as well as playing around more broadly on the trademark search. You can put in things as prefixes or suffixes, whereas trademark checker is you just put in the whole of the mark, and you can also put in logo marks, which is helpful.
So, okay, we've got our brand. We know what we want. We've checked that it's available. We've checked that it's unique. Tracey, what are the actual steps now to register our trademark? What's involved?
So now you're ready to file an application. So as Beck mentioned, there's 45 classes of goods and services. So you need to think about what is it that your business is going to provide, and have a look at the lists and see which classes they fall into. And there is a pick list when you're filing an application that helps you identify what items to choose. Don't just think about what you're planning to sell right away. Sort of try and think about the near to medium term, what your first product is success, what's the next thing going to be. And then in terms of filing the application, you have a number of options, and, it depends on your budget. But if you can afford it, it's always good to use a professional, because they'll make sure that your mark actually is available and that it's filed properly. But if your budget doesn't stretch to a professional, then you can do it yourself online. And IP Australia also has a service called Head Start, a Head Start application. And with a Head Start application, you put in all the details as if you were filing an application, and you get a preliminary assessment from an examiner on whether they're going to raise any objections within 5 business days. And you have an opportunity at that point to think about, based on what they say, whether you should abandon it, whether you need to add something more distinctive to it, whether you need to be more specific about who the owner is. You can't file in a business name, for example. And if you're happy with that, you can overcome any of the objections and make the necessary amendments. You then pay the second half of the fee, and it's at that point the Head Start is converted to an actual application, and you get a filing date. Your application is re-examined, usually by the same person, and whilst there's no guarantees that you won't get a new objection, there shouldn't be. You should already know what the situation is going to be. So once the application's filed, if you've used the Head Start, you're probably going to get your examination done within 5 days. If you just file online, it's more likely to be a couple of months. And if there's no objections, your application gets accepted for registration. If there are objections, you're given 15 months to deal with those objections. And once you're accepted, your application's advertised, which means it's published in an online journal, and people like Beck and her team are looking for third parties who are filing similar marks and alerting them that they should object. And then you're into an opposition. But if there's no objection, you will then get registered, and your trademark registration is valid for 10 years and can be renewed every 10 years ad nauseum, basically.
So we have now a bit of an understanding of the registration process. And you mentioned objections. Beck, can you talk about what do you do if you talk a bit more about what you can do if you get an objection, but also an opposition, and what is meant by an opposition as such?
Yeah, absolutely. So like Tracey mentioned, when your trademark is formally examined, you may receive an objection from IP Australia. It's quite a common misconception that, if you've received an objection that your trademark's been rejected, that's the end of the road. But actually IP Australia will allow you 15 months generally from the date of that first report to try to overcome any objections that they've raised. And they generally are very receptive and can work with you in many cases to kind of overcome those objections if you put forward, things that satisfy the examiner's concerns. For example, common objections would be if the examiner carried out a search when they were examining your application and they located a similar third-party trademark, they would raise that as a conflict objection. And there's quite a few different ways that you can respond to that type of objection to try and resolve the issue. For example, if your goods and services are actually quite different to what the owner of that earlier mark has claimed, you might be able to amend your specification to remove the overlap, and that might allow for kind of peaceful coexistence of the two trademarks on the register. If you've been using your trademark for a number of years in the marketplace, either prior to the filing date of the cited mark or concurrently alongside the cited mark without any evidence of confusion in the marketplace, if you've been peacefully coexisting, often you can provide evidence of your use of the trademark to the examiner, and they will take that into account to look at, how you've clearly got some strong unregistered rights here, which should be reflected on the register, and the marketplace activities demonstrate that the risk of consumer confusion is low. Other options are you can reach out to the owner of a cited mark to see if they would be willing to consent to your application, and if they were to sign a letter of consent, generally you could submit that with IP Australia, and that would, in most cases, resolve the objection. Obviously, that option comes with some risk if you're reaching out to the owner of another mark, because it may prompt them to object to your use and registration. But if the parties are not commercial competitors, that's often a viable way of resolving it. If you think the examiner has assessed the trademark incorrectly, or if there's some arguments that you want to put forward in support of your application being accepted, you can also file submissions pointing to case law that supports your position and things like that as well. So quite a few different things that you can do during the examination phase to try and resolve any objections. The other main type of objection that we see are descriptiveness objections. So when the examiner has assessed that your trademark is not sufficiently distinctive to be registrable, and in that case, again, you could file submissions. You might be able to amend your specification if your trademark's only descriptive in respect of a small part of your goods and services, but distinctive in respect of others. That's an option. And again, if you've been using your trademark in the marketplace for a number of years and you've acquired distinctiveness in that brand, so through your use and promotion of the trademark, it's come to be associated in the minds of consumers as a badge of origin for your business, then you can submit evidence of your use of the trademark for the examiner to consider, and that can often be enough to overcome a distinctiveness objection as well if you've made enough use of it. So that's the examination process. Once your application has been accepted, like Tracey mentioned, it will be advertised for opposition purposes. This is a 2-month window where third parties can file a opposition to the registration of your trademark. They would generally need to establish grounds for opposition. That might be on the basis of a prior similar trademark that they own. Might be on the basis of an unregistered trademark. It might be if there has been some sort of kind of business dispute and they argue that the application has been filed in bad faith, that type of thing. And then for an opposition, each party gets the opportunity to put forward evidence and arguments, and then ultimately the matter is decided by someone like Tracey or someone in Tracey's team.
You can see why it helps to have a lawyer involved in this process, and you can see how much knowledge that our panel has here tonight. Okay, so we've managed to register our trademark now. How do we prevent other people from misusing our brand? Beth, do you want to start?
So registering your trademark is really just the first step. And then once you've got that kind of enforceable registered right, it's really up to you to enforce that. IP Australia does not get involved in the kind of enforcement side of things. So if you were to become aware of a third party making unauthorised use of your trademark, you'd want to take action against them quite quickly. You'd generally start out with a cease and desist letter, putting them on notice of your rights and asking that they cease their infringing conduct. If you allow unauthorised use to go unchallenged, it can be much more difficult to try and stop it down the track because you're, you might be letting that person or that entity accrue their own rights in a similar trademark. So it's important to act swiftly. I think becoming aware of the conduct and taking action quickly is the most important thing. So you want to be keeping an eye on what competitors are doing, keeping an eye on the marketplace, maybe set up some Google alerts for when there's new listings online that feature your trademark, so you can have a quick scroll through there and make sure none of it's unauthorized use. Online platforms generally have some pretty good IP enforcement policies these days, so you can register your trademark with Amazon's brand registry, which can help you get counterfeits and things taken down. Same with Facebook and Instagram generally have IP takedown policies. What have I missed?
Pretty good list. What happens if you if you see somebody actually misusing your brand? What do you do? How do you act on it?
You would generally start with a cease and desist letter, so letting them know about, putting them on notice of your rights in the trademark and what you consider their conduct to constitute. So if you're making allegations that they might be infringing your registered trademark and making some demands about them ceasing the use by a certain date, that might involve providing some undertakings to destroy product that might have the trademark on it and undertaking not to use or apply to register a similar trademark in the future. Majority of the time, these kind of issues can be resolved between the parties and their lawyers without needing to proceed to court proceedings. If they do not comply and it ultimately escalates, then you may need to commence trademark infringement proceedings in court.
That would be a bit unfortunate. What if you're on the other side of the accusation and you're actually being accused of infringing on somebody else's trademark? Tracey, what do you do?
Well, my advice would be don't ignore it, or you might find yourself in court. So I think what you want to do is check the trademark register first and see if they actually have a registered trademark, because as we said, that's cheaper and easier for them to enforce against you, the same way as it's cheaper and easier for you to enforce against someone else. Do some research online into the company. Is there actually a commercial conflict? That'll help you assess how likely is it that they will sue you for trademark infringement, or whether you might be able to work out some sort of negotiated settlement with them, come to some agreement with them. IP Australia has a new tool called IP First Response. You can ask it what you should do, and it will give you some preliminary tips. But in general, like if there's a real commercial conflict, you need to talk to a professional. You need to see a lawyer, because otherwise you might end up with spending a lot of money, in a place no one wants to be.
That segues very nicely over to you, Beck. What do you, from a legal perspective, what should you be doing if you're on being accused of infringing someone's trademark?
I would definitely say that is certainly a situation where you want to get some good legal advice quite quickly. Your lawyer or attorney will be able to assess the strength of your position and advise you of any risks of your conduct to date and potential continued conduct so that you're well informed in deciding what to do next. So yeah, I think definitely getting someone involved at that stage, kind of taking a step back and assessing the relative rights of each party, whether your conduct has actually infringed, what the chances are of them succeeding in an infringement action against you. The strength of their case will inform your position, whether you're advised to cease using and rebrand, or if there is some argument, perhaps you have a defence to infringement because turns out you were actually using the trademark before they registered theirs or something along those lines. So I think definitely having that information and getting a legal opinion on the risks of your position and finding out where you're at and what your options are and best course of action is.
Right. So I think that brings us to the end of the main part of our presentation. We have some fantastic resources, as Tracey mentioned, from IP Australia. You can scan, we will be sending out the slides and a recording from today, but by all means take photos. You can scan to check your trademark and that'll help you to protect it. And we have a few key takeaways from this evening that just summarize some of the key things that we were talking about, which I will not just sit here and read out. I'll let you have a quick read. And there are additional resources from IP Australia that are also very helpful. A number of QR codes. Again, you'll have access to these coming out by email in the next couple of days. And we are going to take your questions shortly. Francis will grab a microphone and take it around for your, to answer your questions. Just before we do, I'm just going to really quickly tell you a little bit about LegalVision's membership. So our membership model is actually unique, and it's almost like having your own in-house counsel, but for a fraction of the cost. It gives you access to over 100 of our lawyers across any of our teams. It is not quite all you can eat, but very close. It has unlimited consultations with our lawyers. So can you imagine if you need to speak to a trademark lawyer one day, an employment lawyer another, contracts the next, you can hop online, book an appointment. You can book as many appointments as you need, in fact, and you will always have that cost certainty. You have also unlimited document review and drafting. So if you need new supplier contracts or you need a third-party contract reviewed, all of that is included and very relevant to today's discussion, unlimited domestic trademark registration. So lots of great value, and we're also offering a complimentary legal health check, just a quick over the phone audit of your business to identify any gaps in your legal health. You can use that icon to book your legal health check and at any point, or have a chat to us after the appointment, after the presentation tonight. So I think we're going to get questions. Would you mind to grab the microphone, Francis? Just grab the one if you don't mind. And we'll take that around.
Yeah, my name is Keith Spencer. I'm a solicitor but general counsel these days. A couple of questions. First of all, we've got in our name, our name is unusual and the way we do our name is quite distinctive. So that's trademarkable. Then we also have the platform, which is also an unusual name, and that's trademarkable as well. Are we better off having two separate trademarks, or can you put the two names into the one? And then if anybody is taking one name or the other, then you've got that protection. That's the first question.
Okay, I'll take the first one then, in case the second one's harder. So in terms of when you're looking at whether somebody's infringing your trademark, it's a question of how similar is what they're using to what you have registered. So the more things you put in your trademark, the more things they can change and not infringe. So, and also the other thing to bear in mind is that somebody can challenge your trademark for non-use. So if you don't use the trademark basically as registered or without any substantial alteration, your registration will become vulnerable to cancellation on the grounds of non-use. So you get much stronger protection if you have the separate names registered. And you also have the benefit that your registrations won't be able to be challenged for non-use.
Thank you. Now the next question is the international trademark protection. Understand this thing's called the Madrid Protocol. How does that work, please?
So the Madrid Protocol is kind of an international system of registering trademarks. It's not a global trademark registration as such. It doesn't automatically extend into every country worldwide. But what it allows you to do is file what's called a parent registration through the World Intellectual Property Organization, or WIPO. And then you can designate under that one registration the different countries, as long as they're members of the Madrid Protocol, which most are these days, designate the countries of interest to you, and they will be examined in accordance with the local laws of each country, but stay under that kind of umbrella and tie back to your international registration, which really streamlines things because you don't need to instruct associates in each of the different countries to file separate applications for you. And it also makes the maintenance a lot more streamlined too. If there's an assignment, you can record that just with WIPO, and it will be filtered down to the designated countries rather than needing to go through an entire portfolio of national applications in different countries to make updates like that. Same with the renewal of the trademark, all can be done through WIPO as well.
But is it standard internationally, like if you went to the Madrid Protocol and you registered, say, Canada and the States, which is what we're looking at,
Mm-hmm.
in England, then if in 12 months' time we're looking at France and Germany, then you wouldn't apply to register it now because they're not using the trademarks in those countries. Would that be correct?
That's a good question. So generally, if you are planning on using it within, say, the next 3 to 5 years, you'd probably want to get the process underway sooner rather than later. In most countries, trademarks become subject to a use requirement only after that kind of 3 or 5 year mark. It varies depending on the country.
Latitude there.
Yeah, you do. And there's also some countries that have quite delayed examination at the moment. For example, in Canada, it's taking upwards of 2 years to reach examination. So I always recommend getting protection underway in Canada as soon as possible. Otherwise, in a couple of years, you might reach the point where you're ready to launch in Canada. Your application hasn't been examined yet. You don't know what the status of your protection is and whether you're at risk by using that trademark in that market.
So there's a filing fee when you file it with the Madrid Protocol, and then as you take it to each country has its own filing fee. So
that's right. Each country sets their own fee. And you can file in your initial countries, and then down the track you can add additional countries as subsequent designations as you expand into different regions over the years.
Okay, so we've already got one trademark registered in Australia for the name. We could piggyback off that internationally.
Can I suggest that we might just
Sorry,
allow other people to ask some questions first, and then we are going to be hanging around afterwards. So if you can ask some more questions then. Of course, if nobody else has any questions, that's a different story. Oh, there we go. There's a gentleman at the back.
Hi, my name is Sean. I just want to know the difference between a word mark and a trademark.
There's no difference in some cases. So a word mark is where your trademark is just a word. If it's got some kind of stylization or it's a combination, maybe you have some words in some kind of emblem or with some pictures, then it's a logo. Obviously, if it's what we would call a non-traditional mark like a shape or a color, then it's obviously not a word mark. So, but often a trademark is a word mark because it's the word that you're protecting.
My name's Paula. With the internet, you could have a trademark in Australia, but not in other parts of the world. But if you are selling online and dispatching from Australia overseas, are you infringing someone else's trademark? Because they're actually buying from an Australian site, and it's being shipped from Australia overseas. So how does that work?
You could potentially, if you're shipping goods and selling to consumers in a particular country where your trademark is not protected and someone might have a similar trademark registered, you might inadvertently infringe that trademark. I guess things are, in this day and age where, people can access websites all over the world to purchase goods, the way that I generally look at it is, if we have a business who says, well, anyone could go online and I would ship anywhere in the world, do I need to register my trademark in all of those countries? Well, ideally, yes, but we know that the costs would often be prohibitive. So the way that I generally suggest prioritizing it is looking at both the risk and the benefit of protecting in those countries. So if you go through each of the markets that you're selling to and focus on the biggest markets, the ones that you're making the most sales into, those are the ones that are going to present the biggest infringement risk to you, because another party might take issue with your use. And then in saying that, those are also the countries where you're getting a reputation in your trademark, which may be the way to kind of look at whether to spend the money to protect it in that country. So I generally look at the size of the market. There's also some countries that are first to file rather than first to use countries, where it's always useful to get your protection underway sooner rather than later. China's one that comes to mind. There's quite a few though. So it's sometimes good to prioritize those countries as well.
Yeah, my question's along the same lines. First of all, IP Australia, if we do that, are only protected in Australia? Are we only protected in
That's
Australia?
right. So if you file in Australia, your protection is for Australia.
Okay, so the online question again. My business is in Singapore. That's where I host it. I'm selling into Australia only. So do I need to register in Singapore and Australia?
So it depends if you're exporting products out of Singapore, then you might want to look at Singapore. If it's like a service or technology based thing where you're I don't know, you have your data center or something in Singapore but it's only accessible in Australia, then probably not. So it somewhat depends on the nature of your business.
So I need a lawyer.
No, not necessarily. You can tell us what your business actually is at the end of this, and we'll tell you what you should do.
The website's based in Singapore. I import products from China and sell them in Australia.
All right. Well, you should definitely have a registration in China, because if the Chinese decide they like your mark, you're not going to be able to get your product out of China. In terms of the website being based in Singapore, if it's only directed towards Australian consumers and it's only possible for Australians to buy product, then you probably don't need Singapore. I mean, if you could afford it, it would be ideal, but did the goods pass through Singapore at all? No, right. So yeah. So you probably don't need Singapore. And if you had a problem, like I assume you could move from Singapore to some other tax favorable country. Yeah, you probably don't need Singapore, but you need China and you need Australia.
Okay. Hi, I'm Daniel. I know the costs with registering a trademark are proportional to the number of classes. Are they also proportional? Sorry, let me ask this a different way. If I were to register a word mark now and then decide to register a logo later, would that also mean double the costs or relative to doing both now?
Yeah, basically, I mean, I don't know. if you give any, some firms might give a discount if you did 2 at a time.
Yeah, in terms of
Yeah, but IP Australia's fees are per application per class, so they don't change.
there can be some efficiencies when we work with some clients on multiple applications at the same time. If we're carrying out a preliminary risk assessment before filing and things like that, often there's some efficiency in doing the work all together. But like Lainey mentioned, members get access to unlimited trademark applications, so you wouldn't even need to worry about that.
Hello.
Sorry if this is a silly question, but for example, like Apple, there would be trademark. If I wanted to use the same name Apple in the same class, but add another name to it, so let's say Apple trainers, but it was still an electronic product, would I be able to do that, or would I be infringing then?
I would stay away from Apple.
No. Sorry, I'm just using like an example.
yeah.
But
It really depends on what we'll really look at is whether there is a risk of confusion there. Are the trademarks similar enough that that consumers might believe that they originate from the same trade source? And entities like Apple and others with big, very valuable brands will go after anyone who uses anything remotely similar in a remotely similar goods or services class. So even if, you know, ultimately it might not end up being infringement in court, trying to defend that, it's best to kind of stay away from those big ones, certainly.
My question is, last year we tried to register IP, the trademark in IP Australia, and we paid extra fee for assessment, I think extra assessment. So what they said is we can't register the name, but we can register the logo. So does that mean some other company can have the same name, similar name, but the different logo?
Possibly, yes.
So that means actually no protection at all. They can still use the name.
Yeah, I mean, it's not ideal. It does depend to some extent how descriptive or non-distinctive the word elements are. So if you have a mark that might encounter some sort of descriptiveness objection, by adding a logo, you avoid the risk of getting an objection. And what you would ideally do is once you have a couple years worth of use of the trademark, you would reapply just for the word mark. There are some marks that are so descriptive that you might have no protection by adding a logo. So as the example I gave before, a fast car wash, if you added a
It was actually a beauty pageant, and it had a name of the country in the name itself. So, yeah, and it had the name of the country because beauty pageant has to have a name of the country. So because if some other company or some other guys, if they copy the name, then what's the use of doing the beauty pageant? It will be the same. The logo will not differentiate.
That's the problem with choosing a descriptive mark and why we don't recommend it. But because in terms of competition, other traders are entitled to run beauty pageants, and if it's obvious that that's what the beauty pageant should be called, I mean, I don't.
So can anyone do Miss Australia? Yeah,
Yeah.
We can do Miss Australia. So they are not protected.
Unless there's somebody already, I'm not really up on beauty pageants, sorry. But if somebody has been exclusively, they've been the only provider of the Miss Australia business pageants for a number of years, then they would have rights, because if you were to run a Miss Australia beauty pageant, people would think it was the same event or a related event.
All right. I think we have time for one more question, and then we're going to wrap up. Does anyone have a question? No?
G'day, how are you? So do you have any rights at all if you don't have a trademark on your I guess unregistered brand?
So if you haven't registered your trademark, your rights are very much dependent on your reputation in the trademark, so your unregistered trademark rights, which are based on, you know, how much you've been using the trademark in the marketplace, whether consumers recognize it as being associated with your business. So you do accrue unregistered trademark rights, even without registering it. But like we touched on before, it's a lot more evidentiary burden is a lot higher when you're trying to enforce an unregistered trademark. So it's definitely more valuable to have your trademark rights registered.
But what does it cost? Like, what are the costs involved? Ongoing costs, like every 10 years? Is it
For
a
a
fee?
registered trademark or unregistered?
Registered.
Sorry.
Registered.
Registered, yeah. So once you register your trademark initially, it's registered for a 10-year period. So you'd pay the official fees, which would be $330 per class for a Head Start application, for example. And then when it comes time to renew the trademark after 10 years, I think the renewal fees are $400 per class for another 10 years. So pretty low cost on the official fees considering the length of protection that you get. The only other time you'd need to kind of maintain the trademark is if, say, someone were to attack it on the basis of non-use and you needed to defend it, but that would be relatively uncommon.
Thank you.
Well, thank you both very much for a really informative presentation and lots of fantastic questions from the audience tonight as well. Please stick around. Our guest hosts are going to be mingling tonight, so if you have any more questions, you're welcome to have a chat with them and to have a drink and something to eat. Thank you very much.